Welcome to Deals and Disputes with the West Webb Law Group.
Hi, everybody. Welcome to Deals and Disputes with the West Webb Law Group. I'm Matt Skye. Today, we're joined by Christy Goldman, partner at West Webb Albritton and Gentry. With extensive experience in estate planning, business law, and real estate, Christy helps families and businesses navigate legal challenges in Austin and throughout Texas. Christy, thanks for joining.
Yeah, thanks for having me.
So let's jump in. Can you tell us the importance of a will? I hear a lot of people talking about the importance of one.
Yeah, sure. So wills obviously are one of those fundamental kind of estate planning tools that we use to help families prepare for their assets and their children upon their passing. So it's one of the most familiar estate planning tools. And the number one reason to get them is just to provide that certainty for your family, for what's going to happen, both in terms of your assets and in terms of children and guardianship and things like that. So the number one reason is certainty.
And why is it so important when someone feels they don't have a lot of assets, let's say?
Yeah, so we do hear this sometimes where folks think, well, I don't have enough assets to justify getting a will, or I don't need one. And for maybe a surprise answer pretty quickly out of the gate, sometimes people don't need a will. It is not a blanket prescriptive for each and every individual. With that said, it is one of the primary tools in our toolbox just to let folks know that they can have a say and that they can go to bed with that peace of mind that they've provided for their family, even when maybe the asset profile is not quite as developed. For example, we see this a lot in kind of the 18 to 30 or 18 to 30 years of age demographic, where you're legally an adult, but maybe you haven't quite had the time to develop out your asset profile. We see that folks feel like, well, maybe I don't need a plan. And the reality is this demographic really ought to set themselves up for success kind of before life hits that marriage and kids time where things are crazy. We like to get that foundational plan in place so that then it just becomes a matter of maintenance. The other factor to consider is that a will is not just to take care of your assets. It is also to ensure that your children are going to the folks you want them to go to, and just to ensure that your family kind of understands your wishes and that they're able to carry those out without kind of the conflict or uncertainty that you may want to avoid.
So you said something interesting to me. You said sometimes you wouldn't advise someone have a will. What would be the circumstances when someone maybe doesn't need one? And what are those circumstances where someone does?
So there certainly is an extremely individualized inquiry, but we have a lot of tools in our toolbox as estate planners. And so while a last will and testament is one of the most familiar options, there are certainly folks where, if I've got a little old lady and she comes into my office, she spent down most of her assets, and maybe she just rents an apartment and just has a couple of cash accounts, we may be able to, yes, recommend that she get into a will, but also be able to do some planning on the front end to hopefully avoid the necessity of things passing through that will. So there are a lot of tools like beneficiary designations, payable on death accounts, transfer on death deeds, a lot of options in our toolbox that sometimes we're not reliant on a will. We also have tools like revocable living trusts that we'll probably talk about more here in a minute that are appropriate if we have kind of higher conflict situations or we may be worried about an estate tax issue. So it really is a highly individualized conversation, but there are certainly folks that will come in and I'll say, a will is not the right tool for you. Either a trust is a better option, or perhaps we could kind of take care of some of this through beneficiary designations or payable on death accounts, transfer on death deeds, things like that. So I always recommend that folks have their goals and their asset portfolio assessed by an attorney and really kind of get somebody who's willing to talk to you about what meets those goals and objectives.
So let's say you have a scenario where people have moved out of the house, the parents don't have a will. Why should they still have one?
Yeah, so good question. A lot of folks do think that a will is only really necessary if you've got minors in the home, right? If you have minors a minor being a child under the age of 18, who would not be able to maybe take title to a particular asset or manage those things on their own. But a will is really, it's a much broader tool, whether your kids are young, under the age of 18, or whether they're adults. A will is really intended to tell the state of Texas, to tell your family legally how you want your assets distributed. So that's whether your kids are are little or whether they're full grown, productive members of society with their own jobs. We still ideally would like to have that certainty of you telling your family and the courts how you want your assets distributed versus the courts kind of having to operate under the default rules set by the legislators of the state of Texas.
But what happens if you don't have one?
Yeah, so if you don't have one, it really is going to depend on, it's such a lawyer answer, right? That it depends. But it's true. It depends on the nature of the asset profile and also what other planning you might have in place. So, for example, if you didn't have a will, but you did have a revocable living trust, which is a different type of tool we have in our toolbox, that's going to create a very different result than if you don't have a will, but you didn't have any other planning in place. So in the absence of any planning, you are really stuck with the default rules that are set by the state of Texas. And while we all love the great state of Texas, there are very few who kind of would choose that default plan set in the statutes. So I always tell folks, even if you haven't come, to a lawyer's office and put pen to paper and written out what you want to happen, you have an estate plan. It just may be one that you don't like because it's the one that the folks in Austin decided on, when they all put their brilliant minds together and wrote down the statutes. So if you are not familiar with that plan, or if you're familiar with it and maybe you don't like it, because the division is not always what people would assume it to be under the default rules of the state of Texas, it is worth taking the time and energy to put down on paper what it is that you do want to happen.
What would you say are the common misunderstandings people have about a will? Are there like a top three?
I'll see if I can get it down to three. I think
You can do more.
Probably number one is that if I have a will, my family will not have to go through probate, or my family won't have to go to court. And that is just false. I don't know who started spreading that rumor, but it's not true. The number one misconception I see is that if I have a will, my family won't have to go through probate. And we're going to talk more about probate here in a little bit, I think, but essentially it's a court-driven public process whereby a will is validated and your executor is appointed by the judge and your assets are distributed according to the terms of your will. Somewhere along the way, somebody spread a rumor that if you have a will, you don't have to go through that process. And that's not accurate. What a will does in the probate process, though, is it makes it shorter. It makes it much less painful in terms of time, energy, and money. So it provides that certainty to your family and the judge as to how you want things done. So it really makes the process much more concise. So that's probably number one. Know that there will still be a probate proceeding, but with a will, with a properly drafted will written by an attorney licensed in Texas, we have a lot of they truly are magic words that we can say that a judge is looking for when they look at that will. And essentially, if we've got the magic words in there, it's going to make that process much less painful, much shorter. And anytime a lawyer says less painful or shorter, you should hear cheaper.
How does a will work into overall estate planning then?
Yeah, no, I'm going to make you go back on your misconceptions a little bit. I only gave you one. So I'm going to give you a few more if you need them.
All right, let's go on. Let's continue back on misconceptions.
Because there are a lot. And they're worth covering. I think number two would be that it's the only option. I think the number two misconception I hear about wills is that a last will and testament is my only option when it comes to estate planning. And that's not true. I think if you talk with an attorney who's well-versed in estate planning in Texas, you're going to find that you have a lot of options. And really, there's an option for every budget. There's an option for every priority, from the simplest estate that really just wants to make sure this goes to my two kids split equally with no headaches, all the way up to, we're going to have a taxable estate and we need to do some generation skipping tricks and make sure we're minimizing estate tax and maybe build some asset protection in there for the long term. There's all kinds of tools in the box, and it's worth figuring out what's the right fit for you. Your conversation with your attorney should go well beyond just a last will and testament. And then third, I think, is that a last will and testament is all I need. I think I would list that as my third biggest misconception. It's not all you need. A comprehensive estate plan, and this does actually kind of lead into your next question as to how this fits into a overall estate planning, is, in my view, a comprehensive estate plan should include an asset distribution document of some kind. That could be a last will and testament. It could be a revocable living trust. Whatever is appropriate for your situation, you should have an asset distribution document, certainly. But you should also have your statutory durable powers of attorney. That's that document for who can step in and kind of run the business of your life if you can't run it for yourself. Or maybe you don't want to run it for yourself. Maybe you're on a fabulous vacation and need to close on your newest rental property. This is the person who could step in and do those things. A full medical suite of documents is ideal in my opinion, along the lines of medical power of attorney, an advanced healthcare directive, HIPAA authorizations, even declarations of guardian. For yourself, if you were to have a long-term incapacity, who would you want the court to appoint to take care of you? That sort of thing. So, and then we really haven't even touched yet on the issue of minor children. I see a lot of times where guardians are really only nominated inside of a will, and that can be problematic. We've seen that play out with clients before where maybe, a will only becomes effective when you die. So if the only place you have named a guardian for your minor children, let's say you've got a 2 and a 4-year-old at home, if that will is the only place that you've named a guardian, but you and your spouse don't make it home from date night, you're on life support at the hospital, a judge is going to look at me like I have two heads if I bring him a will and say, let's get a guardian appointed. I think it is worthwhile to appoint those guardians outside of a will, to maybe name some medical powers of attorney for your kids. So there's a lot of options when you're talking with your attorney that you may want to bring up and figure out what's appropriate for your family. But that third misconception, and I think it did actually answer your next one as well, is it's all I need, and certainly if I were to add a fourth, just as a bonus, I think the fourth would be that a DIY will is okay. DIY wills are keeping lawyers in business. They create more litigation than they resolve, and they create more family conflict than they resolve. So a lot of times, unfortunately, we see that folks who have tried, real quick before a trip to print something out and sign it, and they're really unaware that the way it was executed would invalidate potentially the whole thing. And then there's this false sense of security that I did something, right? So I think my number 4 misconception, and just a word to the wise, would be very wary of the DIY softwares. I struggle because they tend to prompt potential clients, potential will makers with questions, legally relevant questions to answer that the answer itself is something that the person doesn't know, the effects or the implications of how they're answering the question. So I think that would be my 4th misconception is just that DIY is good enough. It's often more harmful than good.
And it makes a lot of sense. Kind of do it once professionally, do it right, and then you don't have to keep revisiting it in the later on. So let's jump to probate. I think we hinted at this a little bit. We hear this term floated around. What is probate exactly for people not familiar?
Yeah, so probate is at its core, it is a court-driven, court-centered process whereby somebody who's passed, their assets are distributed according to either 1, the default rules of the state of Texas, or 2, the terms of their will. Typically, when we're saying the words probate, we're talking about somebody who had a will, and that will is then authenticated, validated by the judge. The executor, who's the person named by the person who made the will, named as the individual to kind of carry out the terms of this will. It's usually a trusted friend or family member, often an adult child or a spouse, if the spouse is alive. The judge will say, yes, you are the person named in this will to be the executor, and sign an order that authorizes that individual to act under the authority that the will grants them as the executor. So they really get that authority when the judge signs the order, and then the executor will use that order. It's called letters testamentary. They'll use that document to, for example, go to the local bank and move accounts from the name of the decedent, the person who's passed, to the name of the beneficiaries. And the bank is going to ask for that order from the court, from the probate proceedings. So that's really what it's intended to do. Now, from a broader scope, it works a little bit like a kind of like a bankruptcy after you pass. In a sense, it's intended to garner all the assets of the estate, get them into one place, get them listed out before the court, and also allow creditors to come forward and make a claim against the estate. So much to many folks' dismay, your debts don't go away when you die. There is a process baked into the probate proceeding whereby your creditors can come forward and make a claim and say this person did owe us money and get those claims settled before the assets are distributed out to the beneficiaries named in the will. So it's kind of a twofold process. It's both to garner assets and get debts paid. And then with anything that's left, hopefully the estate is solvent. Anything that's left is then distributed according to the terms of the will.
So let's say there is a sibling dispute. What recourse should someone take?
Yeah, so if things don't go well, the number one thing I would say is that probate is never a fun place to air your family's dirty laundry, if you will, or to have those disputes kind of become public, right? So one thing to be aware of is that the probate process is public, at least where I practice in Travis County. If you're bored someday, I always tell clients you could go Google Travis County Probate Court and you can actually watch grown siblings kind of quibble on YouTube. And so that's rarely a result that people want. And so one thing I always try to do when I'm talking to clients is say, that conflict over the Thanksgiving table is unpleasant. Conflict in probate is expensive. So that can get very expensive very quickly. You can hire a lawyer as far as recourse. You can spend as much as you want to spend in a probate proceeding. The reality is that dwindles the assets of the estate very quickly, and there may be nothing to distribute. So what I will always talk to clients about when we're doing that initial consultation and we're talking about, goals and priorities, one of the things I'm going to ask is about the family dynamic. And if there is a likelihood of conflict among siblings, or maybe there's an ex-spouse that may come out of the woodwork later and say you owed them money or something like that. If there is really any realistic possibility of conflict arising as the result of your estate being probated, I am probably going to recommend that we look at a revocable living trust as an alternative planning tool, because it really privatizes the transfer of assets. It pulls us out of the court process, and there's much less opportunity for those conflicts to get extremely expensive and extremely public.
So as we wrap up, are there perhaps 3 top things you discuss with clients as you prepare estate plan?
Absolutely. One of them is certainly going to be the asset profile. If we're talking about somebody with $50,000 in the bank, they've sold off all their real estate, their kids are grown, that's going to be a very different conversation than my entrepreneurs or real estate investors who are in the $5 to $10 million kind of net worth range with little kids at home. So there's always going to be kind of a holistic conversation around what do the assets look like? What type of assets are they? Are they likely to appreciate significantly between now and, when this person may pass? We're going to look at asset profile very thoroughly. Another thing we're going to look at is family dynamic. It's equally important in my view, and often I think an overlooked factor in estate planning is family dynamic, as far as, do we have a blended family? How's the relationship with the ex? How is the relationship between the kids? Do these kids all know that XYZ about sibling? And kind of how the family wants to either keep things private, or maybe that's less of a concern. And then lastly, I think would be just goals, across the board goals in terms of budget, in terms of privacy, in terms of conflict avoidance, probate avoidance. Sometimes, probate would be objectively from the lawyer's perspective, quote, not that bad for the client. You read that a lot on web pages, and you'll hear it from Texas attorneys all the time, that probate in Texas is not that bad. And objectively, it's not. Our process in Texas is fundamentally better than the process in some other states. And with that said, I kind of got into this line of work. I'm a reformed litigator. I was a litigator for 8 to 10 years. And I got into estate planning after my own father passed. And I can tell you that objectively, I know as a lawyer that the probate process in Texas is not that bad. And yet I've been on the other side of that as a client and as the executor of my dad's estate. And I can tell you it wasn't that great either. It wasn't something that I would necessarily want to do again. So I think we really have to listen as practitioners to what the client's goals are and trust that they know themselves and their families and their tolerance for, the different dynamics that come into play. And of course, make a professional recommendation based on our years of training and experience, but also listen to their, lived experience and their family's dynamic and try to help them come up with that perfect intersection of this is legally the right answer. Will be tolerable for your family. And also this will achieve your goals in terms of budget and timeline and process. So I think those are the things for me.
It's a fantastic point for us to wrap on today. Everybody, thank you so much for listening to Deals and Disputes with the West Webb Law Group. For more information or to connect with Christy Goldman and the entire WWAG team, visit westwebblaw.com. Christy, thanks for your time today.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.